Clearly you all must know that a judge just entered the room. I've never been able to sort of get the courtroom quiet that quickly. I think I know all of you, but at risk of reintroducing myself, I'm the Dean of the Law School. And I want to thank you for your attendance today as we hear from the Honorable J. Michael Luttig. Here at the University of Georgia School of Law, we are committed to redefining what it means to be a great national public institution, offering a world-class, hands-on, purpose-driven educational experience with a pioneering commitment to affordability and accessibility. That mission is defined by 3 words: prepare, connect, lead. Events like today's 121st Sibley Lecture exemplify that mission. They offer you, our students, the opportunities to connect with true legal leaders before you embark on your professional careers. This lecture dates back to 1964, when the trustees of the Charles Loredens Foundation established the Sibley Lecture Series in tribute to the late John Sibley, a 1911 graduate of this law school whose service to the school and to the state extended over a period of nearly 80 years. Since its establishment, the Sibley Lecture Series has attracted outstanding legal minds from around the country and around the world. On November 30th, 1964, Yale University professor Miles McDougall gave a speech entitled Jurisprudence for a Free Society. And since then, the law school has hosted United States presidents, Supreme Court justices, other distinguished members of the judiciary, and yes, Judge, a few academics, in the spirit of that tradition. And so it's in that grand tradition that we welcome the Honorable J. Michael Luttig. He served in the United States Court of Appeals for the Fourth Circuit from 1991 to 2006. Prior to his time on the bench, he was an assistant counsel to the President. He worked for then Judge Antonin Scalia and for Supreme Court Justice Warren Burger. He was an assistant attorney general in the Office of Legal Counsel under President George H.W. Bush, and after leaving government service, he entered the private sector where he worked for both the Boeing Corporation and Coca-Cola. In a moment, I'm going to invite Judge Luttig to the stand, but I hope you will indulge the introducer's prerogative in sharing with you 2 stories. I first met him in 1998. No, that's completely wrong. I first met him in 1997. This is the perils when you sort of scribble things in your otherwise typed remarks, but I met him in 1997. It's right here. I was the first person in my family to graduate from law school. I had the honor to clerk for one of Judge Luttig's colleagues in the Fourth Circuit, and I was scared. I was really scared. And I remember being at the first sitting of the Fourth Circuit in Richmond, Virginia in September of 1997. And here was this man who followed the law relentlessly, who pursued it without fear or favor, who wrote trenchant analysis, who wrote with passion, who held his clerks to high standards, but no higher than he held himself to. And that man who became a mentor to me for the last quarter of a century was the Honorable Mike Luttig. Story 2. Fast forward to January 6, 2021, where that same man, that same mentor, was put in a situation where he had to counsel the Vice President of the United States as to what his duty was. And on that day, I wrote the following words. In these moments, the indispensability of a lawyer's role is laid bare. Lawyers ensure faithful adherence to the rule of law. They judge. They help change positive law. They help to advance the cause of social justice. To you, our students, you are training for the day when you will be called upon. As a law school community, we are blessed with a faculty and staff whose collective life experience has included many of those moments. And today I would amend those remarks with the following. Because of lectures like the Sibley Lecture, we are also blessed with speakers who are prepared to lay bare to you their own life experience when they are called upon. So whether that is you one day counseling the Vice President of the United States, the CEO of a corporation, or somebody whose life or liberty depends on your advice, I hope that you will learn as much as I have from a man who's been a mentor and a friend to me for 25 years, the Honorable Mike Luttig.
Thank you, Dean Rutledge. It is a high honor to be invited to give the 121st John A. Sibley Lecture at the University of Georgia Law School. If it's possible, it is an even higher honor to be invited to give this distinguished Sibley Lecture by you, Dean Rutledge. I am humbled by the invitation. And thank you, students of the law school. We, the people, in 1787, ordained and established our Constitution in order to form a more perfect union. Today, just over 3 years shy of the 250th anniversary of our nation's birth, the institutions of our democracy and law are under vicious, unsustainable, and unendurable attack from within. American democracy and the rule of law are in peril. America and Americans are at a perilous crossroads. Who is it that we've become, and what is it that America has become? Is this who we want to be? Is this what we want America to be? And if not, who is it that we Americans want to be? And just what is it that we want our America to be? Speaking in a time of not dissimilar tumult in America nearly 2 centuries ago, Abraham Lincoln urged a revival to the Constitution and to the rule of law, a renewed reverence for that great charter for our governance and guarantor of our liberty. Lincoln sermonized with the reverence that he urged, "Let the Constitution and the rule of law become the political religion of the nation." America is in desperate need of such a revival to our Constitution and the rule of law as our 16th president urged for the nation in 1838. A reawakening and quickening to the reverential imperatives of the Constitution from which today we have strayed so very far. America is adrift. We Americans have lost our perspective. We've lost our moral compass, the compass that has pointed us to true north since our founding. And with the loss of our direction, we have lost all perspective. We need to once again reunite around the much more that we have always agreed upon and that has bound us and united us since our founding. And we need to find the perspective we have lost as to the much less that we disagree upon and that now divides us and disunites us. Winston Churchill said that courage is rightly esteemed the first of human qualities because courage is the quality which guarantees all others. It is going to take the courage and the courage of the convictions of the American citizenry and patriots like yourselves for all of us Americans to support, protect, and defend our imperiled democracy, Constitution, and rule of law in what promises to be the trying years ahead. The evidence of the precarious state of our democracy and law abounds all around us, and so it is that these perils are the most fundamental issues facing our nation today. This 236 years since the founding of ours, the greatest nation in the history of civilization. Poll after poll over the past few years shows plunging respect and support for the institutions of our democracy and law. An ominous Quinnipiac poll in the fall showed that America's two political parties, the political guardians of our democracy, believe that, quote, the nation's democracy is in danger of collapse. Mirroring the same concerns of our population at large, nearly 3/4 of both Republicans and Democrats agreed that our democracy appears to be on the verge of collapse. The effort to overturn the 2020 presidential election and the attack on the United States Capitol to prevent the joint session of Congress from counting the votes for the presidency was an unprecedented and grave offense to the rule of law. Yet, according to one recent poll, roughly 1 in 4 Republicans say today that they approve of the former president's supporters taking over the United States Capitol during the January 6th attack. Published just last week, this poll found that 27% of Republicans strongly, or somewhat, approve of the rioters' attempts on January 6th to prevent the joint session from counting the electoral votes for the presidency. And of course, 2 years later, from January 6th, Republicans have again circled the wagon around their presumptive standard bearer in 2024, the same man who attempted to overturn the 2020 presidential election. Both of these surveys are stunning, and they are grim admissions and confessions of what we Americans believe today about our democracy and our rule of law. Today, still in the forefront of the nation's conscience, is that fateful day in January. The treacherous plan to overturn the 2020 presidential election at any cost so that the former president could cling to power that the American people had decided to confer upon the next president of the United States instead was no less ambitious than to steal America's democracy. And over 2 years later, in continued defiance of our Constitution and democracy, the former president and his political party allies still claim that the 2020 presidential election was stolen from the former president, despite knowing that every shred of evidence proves that claim to be false. All the while, this false and reckless insistence that the former president won the 2020 presidential election in a landslide has laid waste to Americans' confidence in their government, their elections, their democracy, and their Constitution. False claims that our elections have been stolen from us corrupt our democracy as they corrupt the nation, as they corrupt us. To continue to insist and persist in the false claim that the 2020 election was stolen is an affront to the Constitution of the United States and to our democracy, an affront that is without precedent in our history and that we must ensure will be without precedent in our future. As we gather here this afternoon, our democracy remains in harm's way, if not in the way of even greater harm today than yesterday. At the same time that our democracy is imperiled, the American public's faith in the rule of law is in a spiraling decline. The January 6th Select Committee to investigate the attack on the United States Capitol has recommended that those responsible for that attack and for the obstruction of the proceedings of the joint session be prosecuted. and the nation awaits the decision by the Attorney General as to whether those responsible will be held accountable for their offenses under the Constitution and laws of the United States. January 6 constituted the single gravest offense against the rule of law in American history, as an incumbent president incited an insurrection at the United States Capitol to prevent Congress from counting the votes for the presidency of the United States. 2 years later, those responsible for that offense against our Constitution and laws have yet to suffer any consequence whatsoever for their offenses. Instead, they wear their role in the events of that day as a badge of honor, taunting America's democracy and her rule of law. With the passage of time, the American public sighs and shrugs in hopeless resignation that the law does not apply equally to all. Confidence in the Supreme Court of the United States, the constitutional guardian of the rule of law, is on the wane. The most recent polling on the Supreme Court shows that not even a majority of Americans believe that our nation's highest court is doing what it ought to be doing. Over half view the court unfavorably. The largest percentage of the public to view the court unfavorably in the past 3 decades. In the fall, as the court was about to begin its October 22nd term, after its tempestuous previous term, the Chief Justice of the United States felt the need to comment upon the mounting sentiment questioning the very legitimacy of the Supreme Court of the United States. One of the Chief Justice's colleagues, Justice Kagan, felt the same need, but she commented differently than the Chief Justice as to the causes for this mounting sentiment. These unprecedented and conflicting public statements by the justices only serve to fuel the growing public sense that the Supreme Court itself has yielded to the politicization that has overcome our country, and that politics, rather than adherence to the objective law, now infuses even the court's work. The tragic and unprecedented breach of the Supreme Court's confidential deliberative process, represented by the leak in the draft opinion in Dobbs, the opinion that only months later overruled Roe v. Wade, only added self-inflicted insult to the High Court's already self-inflicted injury. Indeed, it might not be much overstatement, if any, to say that during your lifetimes, this great nation of laws in which we are privileged to live will effectively decide whether it will live by the rule of law or whether it will live by the rule of politics. So all-consuming has become the politicization of our country, our institutions of democracy, and now even our institutions of law. The assault on the rule of law has long been underway by persons and forces outside our profession. But if we're honest with ourselves, we must acknowledge that the assault is being waged as well from within our ranks, and even by ourselves. Though not so much here in Athens at this great law school, but elsewhere, our law faculties have all but forsaken the teaching of law for the teaching of politics and social policy. They teach not law, but what they believe the law should be. They champion a vision of law and the rule of law as merely something to be manipulated to accomplish the asserted higher ends of their own political and policy objectives. We practitioners of the law, too, more and more pursue our clients and even our own interests, less and less in pursuit and furtherance of the law, and more in undermine of the law and in pursuit of their and our own political and social policy ends. And our courts have opened wide their doors to these essentially political and social policy claims, freely meting out their own political and policy judgments, first to one and then to the other, to their alternating delight and disappointment. But today I don't want to focus on these, but on our institutions of government, which are preeminently and constitutionally responsible for the protection and preservation of the rule of law. For decades now, these institutions have themselves waged a relentless war on that precious object of their responsibility, all the while professing lament at law's nearing politicization and bewilderment as to its cause. For years, our presidents collectively have cynically appointed to judicial position not those who they are assured will uphold the law and are possessed of the constitutional view of the proper role of the judiciary, but rather those who they are assured share their own political, social, and policy views, and will enshrine those views in the Constitution once appointed. This in surrender to their respective partisan political parties' demands, and of course, in abdication of their constitutional obligation. Faithful adherence to the law and to the rule of law has been relegated to a lesser qualification for the office. If one must wonder, it remains a qualification at all. Our Congress must accept equal, if not greater, responsibility for the politicization of our law. As we have seen repeatedly up to and including the most recent partisan confirmation spectacles, Congress routinely demands that candidates for judicial office declare their views, social and political, issue by issue, and it withholds confirmation from those who do not share its social and political views, and pledge to constitutionalize those views as a condition of confirmation to the federal bench. There is scarcely a pretense of concern for law, or for that matter, even the rule of law. Far from that, these politicians are breathtakingly explicit as to their partisan political objectives. Depending upon the person and his or her party, the call is that the High Court must remain or be made so if it is not either more Republican or more Democrat. Is it any wonder that appointments to the courts resemble more political campaign than judicial confirmation? That this naked politicization of the judicial office inevitably leads to the naked politicization of the courts, and in turn to the naked politicization of law itself, cannot be gainsaid. And of course, it has done just that. Where our Supreme Court itself, followed in lockstep by our lower federal courts, has not led the politicization, it has obliged those who have, with decisions that are any more barely disguised acts of raw political will. Increasingly, its judicial decisions are transparently more political result in search of legal reason than legal reason in support of legal and constitutional result. It escapes no one's notice that what are supposed to be decisions of law which under a rule of law should more often than not be opinions of unanimity, are today, more often than not, opinions of fractious dissent. Fractious dissent, not just along the partisan party lines of the presidents who appointed them, but even along the partisan political party lines of the individual justices themselves. What are the odds of such, let alone the consistent odds of such, under a rule of law, we ask? So far down the path toward politicization are we that from the high court, the institution that by constitutional design is to be the ultimate guardian of the rule of law, we now hear only an occasional faint protest that the court is not a mere partisan political institution, as many have begun to believe it is. Of late, we have been scolded by the court that we must not think of justices as Republican or Democrat, for they are not mere politicians in black robes. But these protests of attempted assurance from the court are being met with a skepticism that has been earned by the court. Perhaps it doth protest too much, has come the withering response from the American public. Commenting on the mutually reinforcing effects of politicization of the appointment process and the ever-increasing politicization of the judiciary and the rule of law, the late Justice Antonin Scalia lamented in almost resignation that perhaps the confirmation process has become what it ought to be. That is, if the courts in the end are to be more instruments of politics than, as constitutionally intended, mere interpreters of the law. As for these three institutions and their contemptible roles in the politicization of our law, I would leave you with this today. If the triumph of politics over law is to be, the cause of that triumph will have been the constitutional failure of these three institutions of our government, in whom we the people have entrusted the protection and preservation of the rule of law. And the proximate cause of that triumph, that there will be none left with the moral authority needed to stem the tide of the law's politicization. Those with the moral authority and the primary constitutional obligation to protect and preserve will have long ago lost that authority. A battlefield casualty of the partisan political war that they themselves have waged on the rule of law. Such, I am afraid, is the imperiled state of our union, our democracy, and our rule of law in the year 2023. America can withstand attacks on her democracy and rule of law from without. She is helpless to withstand them from within. The relentless assaults and attacks on our democracy and rule of law from within that we have witnessed and experienced over the past years, of which January 6th is only the most heinous example, are leveled for the purpose and with the objective of drawing into question the very legitimacy of the institutions and instrumentalities of our democracy and law. These kinds of attacks from within our own country are not contemplated by the Constitution and are therefore neither accommodated nor accommodatable by that great charter for our government. And make no mistake, these assaults and attacks have accomplished their assailants' objectives. The pillars of our democracy and of the rule of law are faltering from these attacks as we speak today. With the former president and his Republican Party's determined denial of January 6th, their refusal to acknowledge that the former president lost the 2020 election fair and square, and their promise that the 2024 election will not be stolen from them again, as they maintain it was in 2020, America's democracy and rule of law are in constitutional peril still, and there is no end to the threat in sight. Nor is there any reason that we should expect there to be end in sight. It's been years now that we have borne witness to, if we have not ourselves participated in, these vicious partisan attacks on each other and on these bulwarks of our democracy and law. For years now, we've been told by the very people we trust and entrust to protect and preserve these institutional guardians of democracy and freedom that they are no longer to be trusted, no longer to be believed in, no longer deserving of cherish and protection. If that is true, then it is because those with whom we have entrusted these institutions have themselves betrayed our sacred trust. And it does seem at the moment that we no longer agree on democracy or on the rule of law, nor do we any longer seem to agree on the other ideals, values, and principles upon which America was founded, and that were so faithfully nurtured and protected by the generations and generations of Americans that came before us. Yet, we agree on no other foundational ideals, values, and principles either. All of a sudden, it seems that we're in violent disagreement over what has made America great in the past and over what will make her great in the future. In poetic tragedy, political campaign slogan has become divisive political truth. And there is no reason to believe that agreement about America by we Americans is anywhere on the horizon, if for no other reason that none of our leaders, and therefore none of us, is interested in agreement, at least for the time being. In the moral catatonic stupor America finds itself in today, it is only disagreement that we seek, and the more virulent that disagreement, the better. We are a house divided, and our poisonous politics is fast eating away at the fabric of our society. This is not who we Americans are or who we want to be, nor is this America or what we want America to be. American thinker, writer, and now New York Times columnist David French wrote a marvelous article exquisitely titled "Queen Elizabeth and the Power That Transcends Politics" on the occasion of Queen Elizabeth's passing. There, French wrote, "The politicization of everything is a threat to any nation, but it is especially a threat to our nation." We Americans seem no longer even to recognize, in either sense of the term recognize, the virtues that have been taught, instilled, and celebrated in our society and in all civilized societies since the beginning of time, such as honor, integrity, truthfulness, honesty, humility, selflessness, duty, obligation, responsibility, courage, and country. What would James Madison think of America today? It was he, our fourth president and the father of our Constitution, who declared it a chimerical idea, the supposition that any form of government will secure liberty or happiness without any virtue in its people. Much less do we Americans any longer agree on what's right and what is wrong, what is moral and what is immoral, what is to be valued and what is not. We no longer agree even on what is and is not acceptable conduct and discourse in our supposed civilized society, or for that matter, even on the outer limits of tolerable conduct and discourse in our society. We cannot agree on what is fact and what is fiction, or on what is truth and what is falsity. We disagree on what ought to be the law and what ought not to be the law. We do not even agree on what the law that we agree is law binds us all, and what of it binds only some of us. Let alone do we agree on how we want to be governed, or by whom, or where we go from here, and with what shared national ideals, values, beliefs, purposes, goals, and objectives, if indeed any at all. No society, and certainly no democratic society, can long endure with such polarized disagreement over these most fundamental of matters essential to any union. America is in need of help, and help is not going to come from whence it should. Our elected leaders on both sides of the political aisle have shamefully and shamelessly failed us. As of this particular moment, our Republican leaders have especially failed us, and reprehensibly so. The politicians in today's America only sponsor partisan incitement and traffic in the same, rather than sponsor bipartisan reason and lead in thoughtful deliberation. They have purposely led us down the road not toward the bridging of our differences, but in the opposite direction, away from the bridging of those differences. For years now, taking the lead from these politicians, we Americans have spoken only coarse, desensitizing, dehumanizing, political vile at each other, which enables us to speak to each other without guilt or regret. For too many years now, we ourselves have spoken to each other as charlatanic political gladiators in an arena that yesterday was and today still is annihilative of America's future, not promising of that future. By constitutional order, we, the people of this great nation, confer upon our elected representatives the power that they are then, by solemn constitutional obligation, directed to wield on our behalf and on America's behalf. But today our politicians live in a different world from the rest of us, a different world than that ordained by the Constitution. They live in a fictional world of divided loyalties between party and country, a world of their own unfaithful making. Today's politicians believe that they never have to choose between their partisan party politics and their country, when in fact they are obliged by oath to choose between the two every day. And every day they defiantly refuse to choose, thereby knowingly choosing their bitter partisanship over our beloved country. In a word, our polarized political leaders have proven themselves unwilling and incapable of leading us. As a consequence, we are leaderless in America today and rudderless. It's obvious to all that we cannot hobble along much longer, politically and governmentally paralyzed, hopelessly divided, directionless and undecided as to what we want to be, and what we must do in order to become the America we want to be. Yet still, all it would take to begin to turn America around is a consensus among some relatively small number of our political leaders who possess the necessary moral authority and who would agree to be bound together by patriotic covenant to step forward and acknowledge to the American people that America is in peril. But for 2 long years now, while the nation has languished, not one of these has stood up, stepped forward, and extended his or her hand to the other. If for no other reason than that none today have the commanding moral authority necessary to lead America out of the wilderness in which it finds itself. The blame for this failure of leadership today rests squarely on the Republicans, whose enabling silence has been deafening and whose dishonorable intransigence is unforgivable. The Republican Party has made its decision that the war against America's democracy and the rule of law that it instigated on January 6th will go on. It will be prosecuted to its catastrophic end. In the meantime, to whom do we turn? Our political leaders having failed us. Well, the answer lies in the first 7 words of the Constitution, written by the prophets of our nation's founding. We turn to ourselves, to we, the people of the United States. Perhaps it is fitting that we ourselves must come to the aid of our struggling America. We're the ones constitutionally possessed of the power over our governance and thus over our destiny. Governments are instituted among men, deriving their just powers from the consent of the government. We wrote in our Declaration of Independence, just as we vest and entrust our power in our leaders, so also can we divest them of that entrusted power, or at least divest the demagogues and charlatans among our political leaders who have betrayed us. We began in the midterm elections to purge the ranks of those who have betrayed us, and we must continue that purge in the next election and in the next and in the next. Then, as we rid ourselves of those who have betrayed us, we need to ensure that those in whom we place our trust tomorrow understand better than their predecessors do today that they serve us as our leaders and are obligated by no lesser authority than the Constitution to represent our interests and our nation's interests at the seat of government. Once we have reclaimed our country, our democracy, and our Constitution from the demagogues and charlatans, then we Americans need to resolve to decide again as our forefathers and foremothers decided for us before, who it is that we want to be and what it is that we want America to be. As our case is new, we must think anew and act anew. Abraham Lincoln would urge us. We must disenthrall ourselves, Lincoln would say, from the bondages of our political demagogues, and then map our own way forward, as did our forefathers and foremothers before us. To begin this task of redefining who we Americans are and what we want Americans to be, we need to begin talking with each other again as allies and friends, not as mortal enemies, which our politicians have made us out to be. We need to listen to one another again as human beings and fellow citizens who share the same destiny, the same belief in America, and the same hope for her future. We need to find our lost perspective, refocus more on the much that matters that we agree upon and that unites us, and focus less on the comparatively little of importance that we disagree upon and that separates and disunites us today. John F. Kennedy said, "Let both sides explore what problems unite us, instead of belaboring those problems which divide us." We must look beyond our self-centeredness today to the all that unites us and focus on the shared values, aspirations, and hopes for the future that bind us together into this one nation we call America. We need to rediscover the truths that we once believed to be self-evident. We need to rediscover and, yes, re-examine if need be, as we have always re-examined, the ideals, the truths, the values, and the principles upon which our country was founded and has flourished for almost 2.5 centuries. We need to reawaken ourselves to the vision, truths, values, principles, beliefs, hopes, and dreams which have bound our nation together into the more perfect union that we the people ordained and established and that have made this the greatest nation on earth. We must turn this government back into the channel in which the framers of the Constitution originally placed it, as Abraham Lincoln said. We need to shore up and reinforce the bulwark of our faltering democracy and rule of law, and refortify the institutions of our democracy and of our law. Preserving virtuous institutions is its own noble purpose. David French put it so well. David went on to say, "We Americans can and should grasp that nations and cultures need people and institutions who transcend politics. And as we refortify and re-strengthen the sacred institutions of our democracy and law, we need to inspire among our citizenry a reverential revival to the Constitution and to the rule of law. Above all else, America is a government of laws and not of men. We are desperately in need of a revival that will renew and revitalize the flagging faith of the American people in our Constitution and the rule of law. It is not our politics that defines Americans, or at least it ought not be. Rather, it is our Constitution and our national story that defines us. It is not all of that, we are being told falsely, that will make America great again. Rather, it is all of this that is needed to make America great again. Students of the University of Georgia Law School, one of your moments of calling has come. Perhaps it is the first, but if it is, it certainly will not be the last. We in the legal profession are the stewards and guardians of our Constitution and the rule of law, the foundations of civilized society and the guarantors of liberty. If this sounds as if the lawyer holds a special place in the constitutional order that is our democracy, and that we are weighted by an almost sacred responsibility, it is because we do, and we are. We have a high appointment and a high charge. You, as are all Americans, are being summoned to stand, bear witness, and affirm that you believe in America's democracy, that you believe in her Constitution, and that you believe in the rule of law. You are being summoned to affirm and take oath today that you will preserve, protect, and defend the Constitution of the United States. If you do this, you will rise to your high calling. Thank you for inviting me to give the John A. Sibley lecture today. I am honored by your invitation. Godspeed.
We didn't coordinate this in advance, but I want to make sure Judge Luttig was going to take a few questions. He said yes. So I'll start with the first two. Question one, the picture you paint is not sunny. So question one is, what gives you hope? Question two, to the extent you feel comfortable or instead prefer to demur, could you talk a little bit about when you were called upon to give advice to the Vice President, not necessarily what you said, but how you prepared for the moment when you were called upon?
Well, for 2 years now, I've been asked by everyone in the world, or at least the country, is there hope? And if so, where do I see that hope today? As of literally today, not as of tomorrow, because the sun's going to come up again tomorrow. But as of this moment, I don't see hope for the reasons that none of you see hope at this moment. To explain that further, I would have had all the hope in the world if at any time at all since January 6, 2021, up to today, that the former president and his Republican Party would have acknowledged just that January 6th was wrong, and that we cannot, of course, have that in America. But as you all know, not only have they refused to acknowledge even that for 2+ years, they are now poised to nominate Donald Trump in 2024 on the platform that January 6th was needed. This is the point I made to Congress. These people believe it was needed in America. Think about that. And to this day, not one Republican leader or official that of any consequence has dared break away from Donald Trump. And of course, in my view, the last opportunity was actually this week, when it's been reported that the president will be, former president will be indicted in Manhattan in connection with the hush money payment that he made to Stormy Daniels umpteen years ago. What has been the Republicans' response? Well, how dare the state of New York prosecute the president for that? Imagine what their response is going to be if the Department of Justice ends up prosecuting him for January 6th. So, my January 6th, as it relates to you all, and as I've told it now to 2 groups today, excitedly telling them what it meant to me as it relates to all of you. I began in one of the sessions today with this. The day after my testimony in June, I wrote an essay on heroism, and specifically the heroes of January 6th. And I've been called and asked for every single word and thought that I've ever had or could have over the past year and a half. I asked a reporter in a magazine, a political magazine, to print my essay on heroism. And I said, these are the most important words to me about January 6th. So as it relates to us, the point I wanted to make and did was almost verbatim this. There comes a time in everyone's life, whether public or private, that one is called upon to stand and affirm what he or she believes and what he or she does not believe. That moment invariably comes at a time that would represent great sacrifice to the person who has been called. But if that person answers the call, They are heroes. I'm not concerned about the public heroes. What I wanted to tell the world is that every one of us in our private lives, personal lives, when we are called to stand up for what we believe in, when we do, we're heroes to our spouse, to our families, to our communities, to our churches, to our state, but also to our nation. Today in America is the most surreal moment in our history, in my view, for this simple reason that actually everyone agrees on. But focus on what it is. No one will simply stand up and speak the truth. No one. I, of course, had to testify in front of Congress, and I was honored to do so. All I did was just tell the truth after I took the solemn oath in front of the nation to tell the truth. I'm no hero. The point is, every single other person in America who's been responsible for January 6th, or aided and abetted, or have in its aftermath supported it, either refused to testify before the Congress in response to subpoenas, or have refused to speak otherwise in 2+ years. And all of us who did testify, use Cassidy Hutchison as an example, because she's about your ages. I think she's 27 at the time. Think of that moment. Not one adult would speak a word. And finally, the 27-year-old kid who's got more character and guts and courage than any of those people in Washington have ever had, steps forward and says, "I'll tell the truth." And she was crucified by those people. And I don't know, but probably to this day has 24/7 security. That's an abomination in the United States of America. Questions? I got lots of thoughts. Yes, sir.
Thank you for your time, Connor. I have a question I think about a lot in law school, which is you're obviously in the great position of understanding and articulating what the law is. And you've advocated for that today, but we're all at the start of our legal career, and I at least feel we're probably going to work with people where we're going to advocate for their agenda, in-house, perhaps at a major airline. And I wondered if you could reflect, and perhaps not use circuitous language as people often do, although I don't think you will.
I try not to use circuitous language. I have been accused of my whole life of framing sentences that no one in the world could understand. but that is different than circuity. But go ahead. I understand your point, and I'll try.
If you could kindly tell us how you dealt with being an agent and an expert in the law, having to represent someone's agenda, and being a man of conscience.
Great question. I got that question this morning, and I was glad I did. So now let me just pause for a minute, try to figure out how to put it in English. Point one, as a lawyer, you represent a client. That's our profession. That's what you're supposed to do. It's a sacred profession. You have an obligation to make every argument, every plausible, I'll even say colorable argument of law on behalf of your client. Period. Full stop. What you're really asking about is this. Many times during your professional career, your client will want to do things that are in violation of the law. That will be another moment of calling for all of you in the room. And now I will devolve into clear language. You have no choice at all, professionally and morally, as a human being and as a lawyer, but to tell your client straight in the face, you cannot do this, it's illegal. Now, we got into an extended discussion this morning in which I told the group that more often than ought to be the case, your client's going to say something to the effect of, well, thank you, Joe, for your counsel. We really appreciate it. But we're going to do what we plan to do. Thank you. You cannot walk out of that office without saying to the CEO, the boss, whoever it is, you don't have to phrase it in this way. You're not going to have the power for many years to put it this way, but this is what I said. I said, well, let me tell you something. If you do this, you're going to go to jail. And I'll be the first person as a witness against you, okay? So let's think about this again. You're not going to do this, okay? And I got up and walked out of the room. That's a moment of calling. You're going to have the same moments of calling. We're not here talking about, the gray areas of law. We're talking about, although with this caveat, criminality can arise within the grayness of law. That's why there are such people as lawyers. So throughout your career, make no mistake, you'll come across gray, but you will know from your training that it's wrong and that they will be investigated or prosecuted for it, or both. So now I'm reminded, the example I use that the world knows is my own law clerk, John Eastman. John Eastman is a constitutional scholar and a constitutional historian of the highest order. He advised the President of the United States and the Vice President that the Vice President could overturn the election on January 6, 2021. If you didn't know that, isn't that fascinating that you're hearing it from me? My law clerk, a brilliant law clerk, So what did he do? This answers your question. There were arguments to be made, and he's probably the only person in America who knew them. But they were arguments to be made, and they were more than colorable. Okay? This gets into my main point for you today and for all time as lawyers. When you're asked to do something that you know is not, that is wrong, don't do it. Refuse to do it, okay? This is not, it shouldn't be as hard as it is, but that's because we are in America where we are today. These problems didn't come up in the same number and frequency 100 years ago. Why? Because everyone had a view of what's right and what's wrong, okay? So what did my clerk do? Just digress for one moment. He knew about the so-called independent state legislature theory that was first put forth in then Chief Justice Rehnquist's concurrence in Bush versus Gore. He knew it. Very few other people even knew it. He exploited it. And then, to get around the Electoral Count Act, remember I told you he was a constitutional historian. He's probably the only person in America that knew of the 4 instances in which a vice president of the United States had taken some action on the equivalent of January 6th, quote, unilaterally. Beginning in the elections of 1800, so we're talking about actions that Vice President Jefferson, Vice President Adams, all the way up through Vice President Richard Nixon, things they did on that day. My law clerk argued to the President of the United States in the White House that they should overturn the 2020 presidential election based upon those historical examples of what vice presidents had done going as far back as to the founding of the United States. So, here's a great story for you. I didn't know all that until I'm sitting there that day in June testifying. The Vice President's Counsel is testifying. He's explaining all of this, and I'm hearing it for the first time. In particular, Congress puts up on double screens as big as this room a memo from my law clerk, John Eastman, who said there is both historical and legal support for overturning the election. The Vice President's Counsel, in real time, I'm sitting there, and he says, among other things, to the Congress of the United States, well, you have to understand the 12th Amendment was inartfully written. Now, you put yourself in my position. That's a moment of calling. I'm sitting there going, what on earth is this guy saying? And what do I do about it? I only answer questions, and I got 150 television cameras right in my face. And I'm sitting there going, I cannot let this be said to the nation. So what did I do? The next question that somebody asked me, I just said, Congressman, with your permission, I'd like to go back to the testimony that you just heard from my friend, the Vice President's Counsel. The 12th Amendment to the United States Constitution was not inartfully written. It could not be any clearer. And it was written to mean exactly what it said. Now, for the first time, I'm testifying. I said, for the first time I am hearing this, and I am seeing that my law clerk said that there was a historical basis and a legal basis for this. Let me tell the Congress what he meant by the historical basis. Okay? And I'm flapping, right? I mean, I'm sitting there trying to remember this stuff myself. I had prepared it, I knew it, but geez, I wasn't expecting, And here's what I came up with. The fun part for me is there's no one in the world today who has a clue what I said. So this will blow your mind, but with my apologies, I said, I took a deep breath, and I said to the Congress of the United States of America in that moment, I said, if Vice President Jefferson in 1800 and Vice President Adams in 1804, and if Vice President Richard Nixon in 72 or whatever had done exactly what Donald Trump asked the Vice President Pence to do, I would have laid my body down to prevent the Vice President from overturning the presidential election. So let me unpack that quickly. John was arguing from the historical examples going back to the founding that had no comparison whatsoever, none, to this. That because those vice presidents did what they did, Vice President Pence could overturn the election. Technical law, not me, but even your professors, because everybody else in the profession believes that official acts by public officials are part of the body of law regarding those things. I don't, they do. But that's the basis on which John Eastman told the president that he could overturn the election on January 6th. What does that draw into question? Judgment. I said to Congress, as with everything in life, so also with the Constitution and the law, judgment is all that matters. What did I mean in that situation? I wouldn't have cared what the law was. I wouldn't have cared. Why? Because Donald Trump lost the election. Fair and square. And for him to do what he was proposing to do would be catastrophic for the United States of America. Those two non-legal facts are all that I needed to advise the president and the vice president as to what they must do on January 6th. Judgment. Every day of your life, you will be faced with judgment calls just like that, where, you can spin out, legal arguments in support of your client's claim. Understand today That's not what matters. If you can't spin out, arguments, you shouldn't even be a lawyer. On the other side of that is, if all you can do is spin out arguments, you should never practice law. Is that clear? What got time for one or two more, if anyone has? Yes, sir.
One of the things you commented on was the courts becoming increasingly political in their approach. I find that these days, political ideology and jurisprudential philosophy are increasingly correlated. Republicans are originalists, protectionists, Democrats are constitutionalists. Do you think that because we've been linked to our partisan identity with school jurisprudence, there's any way to make appointments less partisan while preserving jurisprudential value?
Brilliant question. Needless to say, I couldn't talk about anything this for the past year and a half. No one understood anything I said as it was. This is the issue. Okay? But here's the answer. If we could resolve that ourselves within the law, it wouldn't make any difference to the confirmation and to the politics of the law, all right? But, what this young man's asking is the most fundamental question.
Your Honor, could you repeat what the question was?
Yeah. He was really saying that jurisprudential and legal thinking has aligned itself with the two political parties. And that's exactly right. But we've had a war going on in America for half a century now over that disagreement as to what law is. And by the way, what I have said publicly is the Republicans won the war for the Supreme Court with the 11th hour elevation of Justice Barrett, giving the Supreme Court a supermajority of, for now, originalist thinkers, versus the alternative, which I can most fairly describe as a philosophy of law in the Constitution interpretation in particular, that the Constitution was never meant to be static in meaning. No one would ever write a Constitution that's supposed to endure through centuries as if they were writing a statute, for the obvious reason that they couldn't anticipate all that would happen through the duration of time. All they could do and did do is put in the Constitution the principles by which the laws should be interpreted, with some few exceptions of specificity, like the age of the president and things like that. That's what this war has been about. The war began, coming out of the Warren Court era, where, as you probably don't even know, you're so young, but there was a very large movement, literally, to impeach Earl Warren as the Chief Justice, because of what the people believed were the unwarranted interpretation of the Constitution, so as to affect his own policy and the liberal policies. Okay, I'm not prescribing today. I'm just reporting that's a fact. So the first time that the Republicans could answer this. Notice Republicans, Democrats, that's how we talk about law, right? There's a reason, because that's what it's become, all right? But the first time was actually to respond was when Earl Warren left. And who did Richard Nixon appoint? My mentor and first boss, Warren Burger, to be Chief Justice of the United States in 1969, over half a century ago. That began, the all-out war between the two political parties, but also the war for law itself that has culminated today, only for the time being, with a victory by the Republicans. And then the jurisprudence who hold their view of the role of the court in the interpretation of the Constitution. Now, the political parties have glommed onto this for obvious reasons, but to the premise of your question, it's the two parties who determine who's going to be on the federal courts. So, and as I just said, they could care less what the law is. All they want is to be sure that the judiciary and the Supreme Court in particular is filled with people who will deliver them the political and policy results they want. And as I said, of course, that's what we've ended up with for 50 years. That's what's happened. Should we expect it to be any different? No. That's what we've got. Great question. Let's do one more if someone has it. Yes, sir.
Yes, thank you very much for being here. And also, what resonated with me was really the bipartisanship and also just the talks, about the January 6th committee and, also the Republican leaders. But my question was specifically, is given your deep involvement with the committee, do you believe the legitimacy of the committee was compromised at all by there only being two Republicans, of course, Liz Cheney and Kinzinger? And if so, that'd be appreciate if you could elaborate on that, and also how might that impact the legacy of January 6th moving forward as well? Thank you.
Great questions too. Obviously, I've spoken to this for a year and a half. No, it did not affect the legitimacy vel non of the committee. The January 6th committee is and will probably forever be the most consequential congressional investigation in history. Not first because of what it investigated, but rather because of the way they investigated it. I have said that it was the most non-political investigation that the Congress has ever conducted and likely will ever conduct. So, what's the political storm been, beginning with its appointment? As you know, the Republicans wanted to appoint to this committee, some of the Republican leaders in Congress who had been intimately involved in the attack on the Capitol. Now, look, this itself is a political decision, okay? I fell off a turnip wagon, but not yesterday. And Nancy Pelosi is the Speaker of the House. She gets to make a decision. But it was, in my view, totally rational. Certainly, if it provided that the committee was going to conduct itself in the way that it ended up conducting itself, right? She said no. And the Republicans took their marbles and went home. Why did they do that? For the same political reasons that they're continuing in to today, which is They're not stupid either. They're stupid, but they're not politically stupid. They're sitting there going, okay, this is great. Now we can forever attack the committee as being partisan, and and that will be accepted by millions and millions and millions of Americans. It's one of the oldest political tricks in the book. This is what the Republicans did with Ken Starr, right? From the day he was appointed, they set about to destroy him as a person, so that when he did issue his final report, no one would care because it was obviously political. This is what they do in Washington all the time. This is nothing new. That's what the Republicans did around this committee. The only thing that matters is what the committee actually did. So, of course, as fate would have it, why did, according to the Republicans, I mean, this is almost laughable. Well, the Republicans go, oh, well, this was partisan. The committee didn't hear from anyone who had a different view than theirs. This is your moments of calling, right? This is my moment of calling. And you call BS on that. You know why? It's because you refused to testify in front of Congress. You defied the congressional subpoenas. You lied to people and refused ever to say anything under oath because you knew you'd be prosecuted. And you're going to tell us now? We tried to get you to come tell us your side of the story, and you refused. I do know that committee well. You'll never see, as lawyers, you should understand this immediately. Don't think about anything that's been written or reported. Look at what they did. The only thing that this committee did was take testimony under oath from the witnesses, including the witnesses like inside the White House, like Pat Cipollone, the former Attorney General Bill Barr, took their testimony and all the other testimony and played it out in the hearings. There was almost no comment at all by congressmen and congresswomen themselves, except a very short opening statement and or concluding statement each day as to what those witnesses have said. My God, I mean, would that we lawyers could do something, as well as those political people did. Okay, thank you.
Thank you.